Hello, everybody. My name is Lauren Gearhart, and this is week 3 of legal research. So, first, we're going to be talking about constitutions and their role in legal systems. So, constitutions are the framework for a legal system and establish the form of government and the limitations on governmental power. So, they establish the framework for the use of court systems, legislators, and governmental agencies. So the courts regularly act as interpreters of various constitutional provisions to ensure that legislation satisfies constitutional guarantees such as equal protection and due process. Lawmakers also generate legislation within constitutional limits. Agencies also receive their authority from the statutes after the Constitution allows for it. So now we're going to be talking about statutes as primary legal authority. So, as the supreme law of the land, constitutions provide the framework for governments and protection of rights. Statutes, on the other hand, provide specific limitations for legislators and provide like legislative acts governing the details of government administration. Constitutions are created in official foundational convention type organizations, whereas statutes are enacted by legislators in an ordinary legislative process um, by way of majority vote and executive approval. Because constitutions are supreme, no statute may be inconsistent with constitutions. So the type of reasoning used in interpretations of constitutions is usually broad and principle-based because of the open-ended nature of constitutional provisions, such as equal protection and due process. But on the other hand, statutes, the interpretations of statutes relies on the intent of legislation and textual meanings. So statutes have an immediate and operative effect on decisions, regulatory practices, and specific areas of law. So statutes concerning with family law, criminal codes, even education systems, all govern activities at the state level. State level statutes are arguably much like administrative law and often affect the operations of these agencies. An example would be like stand your ground laws, which govern self-defense claims in criminal cases. Now we're going to be talking about administrative law and regulative authority. So most of an agency's power comes from statutes enacted by legislators. So the Constitution does not explicitly mention administrative agencies, but allows for Congress and state legislators to confer authority to these agencies. Nevertheless, agencies are still subject to constitutional protections, meaning agencies can not violate due process or the separation of powers. So agencies interpret both the statutes that give them authority and the regulations that they have to abide by. So agencies can have investigatory and enforcement authority to fine or enforce authority. For example, OSHA, Occupational Safety and Health Administration, is charged with enforceable workplace safety. Okay, lastly, we're going to be talking about court rules and legal influence. So court rules are essential to justice as they provide organization, consistency, and protection for the fairness in the legal process. It dictates how cases are brought, argued, and resolved. So the rule governs the processes that cases are decided not only on the merit of the law, but also within the framework that respects due process and equal access to the courts. So a court rule can influence the course of the case and the outcome of it. Illegally obtained evidence in violation of the Fourth Amendment may be excluded from a case under an exclusionary rule. In cases, this may lead to the exclusion of evidence and eventually dismissal of charges. It can also provide provisionary charges in how we function in court, such as the implementation of Miranda rights. So, thank you.